right, gentlemen, we are prepared to hear from the appellant.
Good morning, and may it please the court. My name is Richard Smith, and I, along with my co-counsel Kevin Bernstein, represent Sarah Chevrolet and Bryant Johnson, its employee in this matter. I would like to reserve 3 minutes for rebuttal.
Yes, sir. You may proceed.
We are asking the court for a judgment notwithstanding the verdict or an alternative, a remediature. The issue before the court today is whether a jury may infer that Mr. Gooden was unable to perform his job, or that he would become unable to perform his job at some point in the future. Based on that, the lack of that testimony, we say that there was nothing to support an award of loss of future earnings, that there was an absence of expert testimony to a reasonable degree of certainty that Mr. Gooden was unable to work, or that he would become unable to work at some point in the future. The case law we've cited from Tennessee appellate courts is clear. Under Tennessee law, causation of a medical injury or condition must be established by competent expert medical testimony.
Let me interrupt you just a second. Your brief raised 2 issues. Are you going to raise 2 issues today, or just focus on this one issue?
We're going to focus on this one issue, Your Honor, and at the end of my remarks, I'm going to suggest that the focus ought to be on the remediature, because it seems that that would be the easiest method to correct the error of the trial court.
With regard to the loss of future earning capacity?
Yes, sir. That is correct.
So are you
yes, Your Honor.
conceding that the record has sufficient evidence on your other issue?
Your Honor, I don't know that I would concede that. I would prefer to say that I would like to focus my attention on the remediature part. The case law in Tennessee says that testimony is not sufficient to establish causation if it is speculative in nature. The testimony should show that the result is reasonably certain and not a mere likelihood or possibility. It's well settled that a doctor's testimony that a certain thing is possible is not evidence at all. It is no more valid than the jury's own consideration of speculation as to what is or is not possible. So what does the record on appeal show? Record shows that the plaintiff had 2 experts, one a medical doctor named Dr. DeLaw, and secondly that there was an economist who is not a medical doctor, but we call him Dr. Strasser, and that Dr. DeLaw saw Mr. Gooden on 5 different occasions as a patient, and I want to focus on the 5th visit, which is June 1st, 2022. This was the last time that Dr. DeLaw saw Mr. Gooden after having treated him from February 2nd, 2022. The testimony that Dr. DeLaw gave at trial said that he saw him on that date in June 1, 2022, that Mr. Gooden had no impairment. He had full range of motion, and that surgery was not justified. In fact, Dr. DeLaw testified at trial that he told Mr. Gooden that he did not need to see a doctor anymore regarding his motor vehicle injuries. Now, over 100 days pass, and Mr. Gooden's attorneys asked Dr. DeLaw to conduct an independent medical exam, which may be somewhat of a misnomer since Dr. DeLaw was the treating physician for the 3 months between February and June of 2022. Dr. DeLaw testified that Mr. Gooden came back in September 21, 2022, and he had several complaints, including that his right shoulder was locking up and that he was having difficulty with sleeping, bathing, and dressing. Mr. Bernstein, my co-counsel in this case, asked Dr. DeLaw, and his testimony was played at trial, if Dr. DeLaw could verify any of those complaints? And Dr. Law said, no, I could not. And in fact, the last time I saw him, what we had determined is that he had no impairment. Dr. Law gave no further comments on impairment or on his full range of motion or whether surgery was justified. And the question was put to Dr. DeLaw by Mr. Bernstein, so do you have any idea what caused the onset of these complaints that you found in the IME? Dr. Law said no. As I'd said before, he had full range of motion. All I can tell you is maybe the steroid shot wore off, maybe something happened. I cannot speculate. The testimony shows that Dr. Law did not know what happened in the intervening 100 days, 3.5 months. I don't know what happened, and I cannot speculate. And so we return, Your Honors, to the Tennessee case law that says that a doctor's testimony that a certain thing is possible is not evidence at all. It is no more valid than the jury's own speculation as to what is or is not possible. I want to now address to the question of Dr. Strasser's testimony, who was an economist and a very gifted academician. I asked him on cross-examination, have you seen anything in writing that suggests Mr. Gooden is going to lose his job based on what UPS, his employer, is telling him? Dr. Strasser said, no, I have not seen anything that he's going to lose his job. I also asked him about if he had seen anything or had any evidence that Mr. Gooden was going to have surgery. And the reason that those two issues, losing his job and having surgery, those are the linchpins that Dr. Strasser admitted that his opinions regarding Mr. Gooden's lost earning capacity was based on. Well, first, Dr. Strasser says, I've not seen anything to suggest that he's going to lose his job. I followed it up with these questions. As I understand the issue that you're trying to differentiate, that there is a vocational loss of earning capacity. Is that what you are being tendered as an expert to give an opinion on? Yes, sir. And in this case, since Mr. Gooden is still working, and Mr. Gooden worked up all the way through trial, Mr. Gooden has not suffered an actual loss of earning capacity at this point, and Dr. Strasser said that's correct. But in terms of you being able to tell the ladies and gentlemen of the jury that Mr. Gooden is going to lose his job in the future, you do not have anything from UPS that says that's going to happen, correct? No, nothing from UPS right now. I ask, all right, and again, it just goes back to if, may, possibility, but nothing definitive. Certainly nothing to a reasonable degree of certainty, correct? And Dr. Strasser said that's correct. So the two linchpins holding Dr. Strasser's testimony together about supporting his opinion, if Mr. Gooden loses his job and if Mr. Gooden had surgery, Dr. Strasser had to acknowledge that he had no evidence and had seen no evidence in the medical records to support either of those positions. Now, that then takes us back to the question. In most states, and I believe that Tennessee follows most states' authority on this, that testimony offered by a qualified expert is admissible on issues of loss of future earnings. And we don't dispute that Dr. DeLaw has great credentials. He's a very talented orthopedist. But there is no evidence in the record to establish that Mr. Gooden is going to either lose his job or that he will not be able to work in the future. And if the testimony, as case law says, should show that the result is reasonably certain and not a mere likelihood or possibility, then the award of loss of future earnings cannot be supported. There is no testimony in the record that his injuries have caused or will cause a loss of future earning to a reasonable degree of certainty. And, Your Honors, that should be the standard, as with any claim for a condition or a medical injury. There should be expert testimony to back that up to a reasonable degree of certainty. And I want to say this, Mr. Gooden's counsel tried a great case, but and we agree with him, as he cited in his brief, that Tennessee does not require an absolute certainty for proof of medical causation. But Tennessee law does, however, require a reasonable degree of certainty, testimony that was never stated by Dr. DeLaw or any other medical expert. And that is why, Your Honor, we are asking the court to remit the verdict award by $225,000, which was the line item on the jury verdict form. And by reducing that amount, that would solve the error. We acknowledge that Mr. Gooden was injured. It was a rear-ended collision on an interstate. It'd be hard for us to argue that the judgment ought to be set aside completely, and it would serve no judicial purpose to have to retry this case when the remittiture would be sufficient to address the error that we are raising with the court. So that is the position of defense counsel. I'll be happy to answer any further questions from the court. If there are none, then I will reserve the rest of my time for rebuttal.
See none.
Thank you so much.
Morning, Your Honors. Eric Llewellyn for the appellee, Randy Gooden. So the appellant has focused on the remittiture argument today, so I'll start there. The standard that Your Honors will have to apply when determining whether to remit the jury's verdict in this case is the material evidence standard. We've cited case law in our briefs, which the Meals case says that that's a very deferential standard. The Bourne case refers to it as a, quote, extraordinarily high standard. The court's only concern when determining whether to remit a verdict is whether there is any material evidence in the record to support that verdict. In the Hohenberg brothers case, the court has indicated that it doesn't matter the weight of the evidence or where the preponderance lies. If the court finds any material evidence at all to support the verdict, it must be affirmed in deference to our constitutional right to jury trial.
What did the plaintiff testify regarding his future earnings?
So I would note at the outset that the trial court explicitly found Mr. Gooden's testimony and the testimony of his wife to be credible, which is an important consideration. And what his testimony was that he continues to have pain and difficulty performing his job duties, that lifting overhead and overhead work and lifting at all are difficult for him. He's a UPS driver. He sometimes has to have customers assist him with larger packages, actually come out to his UPS truck and help him get the package off the truck, which is something that did not happen before this incident. He testified that he is working because he does not have a choice but to provide for his family. But he is concerned about how long he can keep it up, that he worries about whether he will be able to continue enduring this job, which is, as Dr. Strouser testified, beyond the restrictions assigned by Dr. DeLaw. And I mentioned Dr. Strouser. I should point out, Dr. Strouser is not an economist. He's a rehabilitation psychologist with a focus on returning disabled people to work. We did call an economist at trial, but that was Dr. Ralph Scott. So just to clear up any misperception about that. So the material evidence supporting the loss of earning capacity award is Dr. DeLaw has testified that Mr. Gooden has permanent restrictions related to lifting and overhead work and work away from the body. We have testimony from Mr. Gooden and Dr. Strouser that his current job at UPS is inconsistent with those physical restrictions. We have Mr. Gooden's own testimony that he's concerned about how long he can continue doing this work. When asked what he would do with any award for loss of earning capacity, he told the jury that he would try to shift into something less physically demanding and use the verdict to offset the economic loss he would suffer for that. Dr. Strouser also testified, based on his experience in the field, that people have a significant time limit on how long they can continue to perform work that is outside of their physical limitations assigned by a doctor, and that he would expect at some point Mr. Gooden would burn out of doing that and no longer be able to. And the analogy I sort of, think about is if I go to the doctor and I have high cholesterol and the doctor says, you should really stop eating eggs and bacon every morning. Well, that doesn't mean I'm suddenly physically incapable of eating eggs and bacon every morning, but it's a good idea for me to follow my doctor's instructions. Similarly, it would be a good idea for Mr. Gooden to shift into something that's less physically demanding, physically taxing for him. It will help his health with his shoulder. It will cause less pain and will reduce the likelihood of re-injury. So that's the evidence in the record that he is not going to be able to continue doing this job long term.
The point that you just raised, I recall reading that, and so this issue of someone working outside of what their limitations or exceeding their limitations as far as what a doctor has proposed, that was an issue that was specifically discussed during the trial, and evidence was presented on that, or at least testimony was presented on that. Is that correct?
Yes. Mr. Gooden acknowledged from the stand that he was continuing to work as a UPS driver, which was the job he had on the date of the injury, and defense counsel argued extensively that fact undercut our claim for lost earning capacity. But thankfully...
One more question.
Sure.
Before you go somewhere else with this. Did your expert testify about some period of time that a person could reasonably expect to be able to work outside those limitations before it eventually caught up to him, I guess, is another way.
I'm going from memory, but my recollection was that the estimate that Dr. Strouser, or the estimate Mr. Gooden put on it, was 5 years. He's like, I feel like I maybe have 5 years left doing this. Dr. Strouser, I can't recall specifically. He did suggest there was a significant time limit on how long you could expect someone to do that. I cannot recall as I stand here at this moment.
It would be less than 5 years, I assume.
He gave a year, like whether he put a specific number of years on it. But he did express that in his professional opinion, he would expect there to be a limitation on how long that could be done, because people experience re-injury or the pain increases to the point where it's no longer bearable. And another argument that the defendant has made is, well, how can he have a loss of earning capacity if he's still working? And what we informed the jury and argued at trial is that under the Overstreet case, earning capacity refers not to actual earnings, but rather to earnings that a person is capable of making. And Tennessee Pattern Jury Instruction 1401, which the jury received in this case, indicates that there may be a loss of earning capacity even though there has been no loss of earnings, and even though a plaintiff made more after the incident. That is a sensible law and instruction, because in many cases like this one, people push themselves to do what they have to do out of economic necessity, even if it's inconsistent with their doctor's instructions, and the law allows them to recover for that so that they don't have to incur that financial loss before trial in order to make a claim for loss of earning capacity. So to argue that his return to work and continuing to work through trial bars his recovery is just inconsistent with Tennessee law. Turning to the permanent injury argument that was made in the defendant's brief, the question on that, since they've made a motion for judgment notwithstanding the verdict, is was there sufficient evidence in the record to create an issue for the jury to determine on that question? And in making that determination, this court, of course, must review the evidence in the light most favorable to Mr. Gooden, make all reasonable inferences therefrom, and discard any evidence to the contrary. So what's the evidence for permanent injury? The first thing is it's undisputed that Mr. Gooden had never had any right shoulder pain or treatment prior to this incident. He started experiencing pain in his shoulder on the day of the incident, sought treatment that day. He went to Campbell Clinic where Dr. Dockery diagnosed him with an acute shoulder injury caused by the wreck. That record, Dr. Dockery did not testify at trial, but his record is Exhibit 8 in the record where that diagnosis can be found. MRI films show that Mr. Gooden had interstitial tears of his rotator cuff tendon and impingement syndrome of the right shoulder. Even the defendant's expert, Dr. Christian, acknowledged those MRI findings. Mr. Gooden treated for roughly 6 months with Dr. DeLaw. Dr. DeLaw saw him on 5 occasions, performed injections, reviewed the MRI films, ordered physical therapy. The shoulder pain never went away. That was Mr. Gooden's testimony, that from the time this wreck happened, he'd never had shoulder injury pain before, and since the wreck, the shoulder pain has never gone away. Based on his treatment of Mr. Gooden, his review of all the records, his review of the MRI films, Dr. DeLaw unequivocally and clearly testified on multiple occasions that he believed that this wreck caused an injury to Mr. Gooden's shoulder and that it was a permanent injury. Now, the line that the defendants want you to focus on is a specific question about the change in Mr. Gooden's range of motion between June of 2022 on the last date of treatment and September of 2022 when the IME was performed. This case had a companion workers' compensation case along with it, and as I'm sure your honors are familiar, the treating physician treats the person for a while and then eventually they have them back to determine impairment and whether they're at MMI and assign restrictions, and that's what happened in this case. So on the last treatment visit, June 1st of 2022, Mr. Gooden was noted to have popping and a sensation in his shoulder when it locked up. He was described as being, quote, miserable, close quote, with pain on that date, and he was very much still complaining of difficulty with that shoulder. It is true that in that June, his range of motion had improved, and on that date, he was able to achieve full range of motion in his shoulder. When he returned in September, that was really the only difference in his condition. He still had pain, he still had the locking, he still had difficulty lifting his son. All of the other problems he'd complained about were still present in September, but his range of motion had degraded between June and September. And when asked specifically, well, why did that happen, Dr. DeLaw acknowledged that he did not have 100% confidence of why the range of motion would have changed between those 3 dates. But he did offer a couple of potential reasons. He suggested that perhaps the steroid injection that Mr. Gooden had been given had worn off. He also suggested that you sometimes see that with people, that when they stop treating and resume their normal activities, they sort of have a recurrence of symptoms that maybe had faded over time during treatment. So he did postulate some potential causes for that reduction in the loss of range of motion, but he acknowledged that he was not 100% certain about what caused it. But the lack of certainty about that one particular point about why his range of motion decreased over this 1 3-month period is not fatal to the rest of Dr. DeLaw's opinions. Dr. DeLaw saw him on 6 different occasions, examined him multiple times, took his history multiple times, reviewed all the records, reviewed the MRIs, and he was confident in his opinion that there was a permanent injury caused by this wreck. And it's also, defendant has at times attempted to misleadingly suggest that, Mr. Gooden was healed and was fine in June of 2022, which could not be further from the truth. He was miserable on that date, as noted in the records. So this minor fluctuation in his range of motion in his right shoulder and Dr. DeLaw's ability to account for that with 100% certainty should not be used to completely discount the rest of Dr. DeLaw's opinions, particularly under the standard that has to be applied in this case, where all facts are taken in a light most favorable to Mr. Gooden and inferences made on his behalf. So really the core point that the defense is trying to make about his uncertainty on that one issue is just not enough to throw out the jury's verdict. It's also not enough to say that the evidence in the record should not have been presented to the jury. I mean, I've gone through the evidence that Dr. DeLaw testified about, and that evidence is enough to create an issue of the permanence of the injury for the jury. And the Orman versus Williams Sonoma case that I've cited has acknowledged that, quote, absolute certainty, close quote, is not required for proof of medical causation because absolute certainty can almost never be achieved in a medical situation. Dr. DeLaw's opinions are well-founded and based on a significant amount of evidence. And based on that evidence, there was enough for that issue of the permanence of the injury to go to the jury. And I'm near the end of my time, so unless there are any questions, I'll be done.
See none. Thank you.
Thank you, Your Honors.
Judge Stafford, I think you put your hand right on the issue in the question you asked about whether there was any medical testimony about when Mr. Gooden would be unable to work. But the best that the plaintiff could come up with was a statement from the plaintiff himself, where he said that he might be able to work 5 or 6 more years. But it is the complete absence of testimony by a medical doctor to a reasonable degree of certainty. No one told the jury this man is unable to work right now. No one told the jury that this man is not going to be able to work in 5 years or 6 years.
What did the vocational expert say?
The vocational expert admits he's not a medical doctor. He says that he has seen people that sometimes have these conditions and sometimes they work for as long as they want to work. And some people don't work. The issue is, though, the burden is on the plaintiff to show
What did he say?
that some people could work long periods of time, but he did not.
Did he give a specific time frame?
No, sir. No, Your Honor, he did not. And that's part of the problem here, is that the plaintiff could have asked Dr. DeLaw or asked Dr. Strasser, is this man unable to work, or do you have an opinion, an expert opinion, on when he will be unable to work? They did not ask that question. Now, I tried to get into that with both Kevin with Dr. DeLaw, and I did with Dr. Strasser. When I asked Dr. Strasser, what is it that is holding your opinion together about your belief that he is going to be entitled to loss of future earnings? And he said, if he loses his job or if he has surgery. Dr. Strasser admitted there's nothing in the medical records showing either of those two things.
Did Dr. DeLaw put limitations on his work that are inconsistent with a UPS employee?
There are plenty of jobs that UPS employees are doing with the restrictions that Mr. Gooden was doing, including Mr. Gooden. And, Your Honor, I recognize that I don't want to sound unsympathetic to a man who's working. I appreciate the fact that Mr. Gooden was trying to continue working, but this underscores the point that he is not unable to work, nor is there any testimony to a reasonable degree of certainty that he will be unable to work in the future. And to allow a jury to speculate on, well, there's no definitive testimony, and I asked, do you have anything definitive? And Dr. Strasser said no. To me, that is the problem, Your Honor. And of course, it's up to the court to decide if the evidence submitted was sufficient or not, but I submit that based on existing Tennessee law, the burden is on the plaintiff to show that the result is reasonably certain and not a mere likelihood or possibility. And I say my red light is on.
Thank you. Thank you, gentlemen. We will take this matter under advisement, and we'll attempt to get you an opinion at the earliest possible time.